Hey, beautiful people. Welcome back. Why this thing called due process is implemented into the rules. Most rules hear that rules are to be stayed away from because rules are bad. Rules are friends legis, and so and so. But they fail to realize that these rules that they're speaking of are only bad if and when it is unconstitutional, and if it's bad, then it is their responsibility to speak up and change it according to the rights of readers and grievance. These things called rules of evidence on a state or federal level, did you know that they are actually passed by the Congress? In order for it to be used and applied to the public at large in any way, shape, or form, even if and when it's within the judicial department, the Congress still has to have their hand in it. The Congress being the department of government that actually makes the law. The rules of evidence, if you look very close, you always see the Congressional session, the number of Congress that created whatever rules, whether it's evidence or appellate or civil or criminal. These are laws. In other videos, we've went over the fact that rules is simply operation of law. They're the vehicle to which laws are enforced. The origin of this thing called rules of evidence that we speak of ever so often, which is the core of how everything you say and do at any given court venue, publicly or privately, if you are at North America, in a state or federal level, because the states have their own rules of evidence which are uniform with this, in many cases, word for word, line by line, item by item. These will be used as a scrutiny for whatever claim that you're bringing in. If one does not know this, they're just walking in blindly in a battlefield on a horse against tanks that shoot ammunition that are as big as the horse that you're riding on. That's a huge disadvantage. For you to comprehend the playing field itself so that you will be able to understand what you need to do, so that you'll be able to comprehend what you need to do, what you need to bring into the battlefield, and what the terrain is like, and what equipment are used. You will need to know this. But to those who are hesitant, the origin of federal rules of evidence is congressional in nature. Public Law 93-595. An act to establish rules of evidence for certain courts and proceedings. For certain courts and proceedings, meaning federal court. If you go on a state level and you look at the public law and the public act, the session law, the congressional laws, the slip laws of your state, the same foundational principles will exist. In each state constitution and on the federal level, it speaks about certain types of courts. On your state level, there will be specific sections that speaks about the judicial department, just as much as there are specific sections that speaks about executive department, just as much as there are parts that speaks about legislative department. In the 1870 Illinois Constitution, that has a legislative department section, that has an executive department section, and then judicial department. These are the specific types of court within the state. Your constitution will tell you which court is equitable or not. Your constitution will tell you which court is statutory or not. Your constitution will tell you that. Literally. How many people going on about bad court, good court, this court, administrative court, this and that? How many people know that? Do not let people feed you a pie in the sky until you read it for yourself. Be well acclimated with your state's constitution, because the equivalence of this rule of evidence on a federal level, which is a uniform one based on the incorporation doctrine, and many more other things, exist on a state level. On a federal level, where the delineation of different types of courts, remember, tells you certain courts, where the different types of courts exist on a federal level, since this is a federal public act. It's in a good old Article 3. We all go on about Article 3 court, right? Well, on Patreon, we speak about exactly what makes an Article 3 court. It's not what you think. It's not the physical structure. And it's directly tied to Article 1. What makes an Article 3 court, or what makes a court in the first place, is nonetheless tied to the first article. Because the Congress, the legislative department, works hand in hand with every other parts of the government. Whether it's your government or whether it's not your government, it is a form of government in and of its own. It's a body politic. You don't have to like it. You don't have to hate it. It's simply what it is. It's a foundational principle that operates, whether you like it or hate it. And if you're going into a battlefield against that thing, whether you like it or not, and you don't comprehend how they function, you will keep getting your butt kicked. The second article of the United States Constitution speaks of the executive department. The third speaks of the judicial. They even tell you it's a branch, like a tree. And these give you the delineation of the different types of court in the hierarchy of power as it relates to the first article, which deals with legislative branch. At this point, people ought to know this basic. Albeit, something tells me if you were to ask someone who goes on about rights here and there, ask them, what really makes a court? What is a court? Beyond the whole banter of your court is your paperwork, what is really court according to the Constitution? State or federal, they would not be able to tell you. When you ask them what is an Article 3 court, they'll tell you it's a constitutional court of record. Okay, what is a constitutional court of record? They're not going to be able to tell you succinctly. Relax your incompetence and open yourself up to the world of competence. Only then would you ever be successful with what you do. But not to deviate too far, this rules of evidence, which is the operation of law, and their substantive law, which is the operation of substantive laws, is a congressional act, is a legislature. It is a law of its own. When I say evidence is a law of its own, evidence is a law of its own, when that's repeated over and over again here in these videos, those are not mere words. To establish rules of evidence, Public Law 93-595, January 2, 1975, House Resolution 5463. The House resolutions are the discussion within the 16 stages of how laws are made before they're actually enacted into public laws and state laws. Federal rules of evidence, and then they show you how they codified it, which is the 28 U.S.C., which is the judiciary part of the United States codes after the public law are codified, that speaks about judicial related stuff on a United States level, that being 28 U.S.C. Right here, Title 28 U.S. Codes. What does it deal with? Judicial related stuff. The organization of courts lets you know. The Department of Justice, dealing with the judicial powers. The court's employees and officers. Believe it or not, this tells you where their oath of offices are on a federal level. And the jurisdiction and venue, how it's determined on a federal level. The procedures involved in it and the particular proceedings. Anything judicial related is in Title 28. And guess what? That's just after the fact. Something preceded this right here. And anything else this could have possibly incorporated or omitted, because the United States codes can willingly omit substantive fact and substantive law that's written down on a congressional level. Why? Because they're not obligated to. It is not the true positive law. Being enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that the following rules shall take effect on the 180th day beginning after the date of the enactment of this act. These rules apply to actions, cases, and proceedings brought after the rules takes effect. People tell you acts, rules, and statutes are for dead people and are unconstitutional. I'm here to tell you to the contrary. You are wrong. Rules, acts, and statutes by themselves are not unconstitutional. When the language itself contradicts the intent of substantive law, which is the Constitution either on a state or federal level, then it's unconstitutional. But when it's in harmony with the federal or state constitutional or the state constitution, then it's not unconstitutional. These things people throw blankets on, that acts, statutes, and rules are unconstitutional. It's not what it is. Stop throwing blankets on things that ought not to be covered. You have to know the intricacies of something for you to determine whether it's constitutional or not. Most people who throw that blanket to say that acts, rules are unconstitutional, it's their stuff, it's unconstitutional. That's a lazy man and lackadaisical way of saying, I don't want to learn anything about my rights. For me to be able to determine and look at the intricacies of what's being used against me to say, okay, this is right or this is wrong, and whether I can actually do something about it. Most people don't want to determine and study what's right and what's wrong, so they just throw a blanket out there. So much so that they defeat their own intent of saying that they want to be free. Do not be a hypocrite, and do not fall for the okie doke and the hype train. Rules of evidence were created by congressional law. Rules of evidence are law of its own. It goes to tell you the same thing you will find when you look at rules of evidence. Rule 101, scope, purpose, ruling, limits, limited admissibility, judicial notices of adjudicated fact, scope of rule, etc. Rule 201, all these things that you're looking at here, you see the exact same thing here. Rule 201, judicial notice of adjudicated fact, scope, kinds of fact, taken notice. All that has its rule here. You have to follow the trail. And the thing is, they update these every year. So much so that when you look at it at the beginning of it, besides the fact that it tells you which congressional session and which number of Congress, it also tells you which date it's active. It also tells you which number of printing it is during the slip. You can Google Federal Rules of Evidence or whatever state you're in, Minnesota Rule of Evidence, New York Rule of Evidence, Texas Rule of Evidence. And it will show you different years, just like each state's constitution have different years. Imagine someone who doesn't know this, but finally stumbles upon Rules of Evidence and say, okay, you know what, maybe I'll start reading it. And they read the one that's in 1993. And they try to make that admissible and try to use it, talking a lot of trash. They're setting themselves up. These are the subtle substance and intricacies in what you call your rights that you have to know. Because these rules are the vehicle to which rights are enforced. And these rules have their origin in language of some type of law, one way or the other. Like you would read some IRS forms, W8 ban, W4, so and so. All those have their origin in some type of meeting that took place somewhere that says, okay, this is how this form is going to be structured. And when those new forms are changed after a year, there's a meeting that also took place to say, hey, we're going to omit box 4, or we're going to remove this word from somewhere. Those forms don't exist randomly. These rules don't exist randomly. There's an origin to it. Instead of you running away from it, know that it's your responsibility to look at it and make it right if there's something wrong, rather than throwing a blanket that, oh, it's all unconstitutional. Then you're showing that you're not responsible about what you say your rights are then. The longer you do that, the more the people that you hate so much will keep kicking your ass. Be truthful to yourself. If you don't care about yourself, at least care about those who are going to be coming in front of you. Until next time, take your best of luck. Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people to make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust-related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not, the intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that our YouTube are synonymous with things that are for the birds. One on the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways when it comes to the express trust 98 number. We went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More in discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how and importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference and the truth of legislative fact compared to adjudicated fact and what it really means when it comes to judicial notice. We speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies. Tax evasion. We show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We speak about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. We speak about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort. Speak about speak about trust. Speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right, the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things in nature, how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.